Have you ever imagined a world where you no longer need the government's permission to defend yourself? Where your right to bear arms isn't buried beneath red tape and bureaucratic lies? Well, that world just became a reality, and it's shaking the entire foundation of American law. Because what the Supreme Court just did doesn't just change gun laws, it completely rewrites the relationship between the citizen and the state. And now, for the first time in history, the Department of Justice isn't suing to restrict your rights. They're suing to protect them. Yes, you heard that right. The same Department of Justice that has spent decades prosecuting gun owners just filed the first lawsuit in American history designed to defend them. The Supreme Court has spoken, and this time, it's not a whisper. It's a thunderclap echoing across all 50 states. Constitutional rights don't need permission slips anymore, and the bureaucrats who've been hiding behind stacks of paper, denying Americans their rights, are about to face something they never thought possible: federal prosecution. This story starts in California, but the tremors are already being felt nationwide. So before we break this down, make sure you stay locked in, because by the end of this video, you'll understand why this moment could redefine freedom in America forever. For more than 70 years, a silent system of oppression operated in plain sight. It had a polite name: May Issue. But in reality, it was nothing more than legalized discrimination wrapped in bureaucratic language. Under the May Issue permit regime, local officials had total control. They could deny your right to carry a firearm simply because they didn't like your face, your politics, or your neighborhood. In states like California, New York, Maryland, Hawaii, and New Jersey, millions of law-abiding citizens were forced to beg, literally beg, for the government's permission to exercise a constitutional right. The statistics were staggering. In some California counties before 2022, approval rates for concealed carry permits were under 1%. 1%. That means 99 out of every 100 honest Americans who applied were told, "No, you don't deserve to protect yourself in New York City, a metropolis of more than 8 million people. There were fewer than 5,000 active carry permits." That's not gun control. That's population control. It wasn't about safety. It was about power. And it was making a mockery of the Second Amendment. For decades, politicians built their careers on this system. They raked in campaign donations, pandered to fear, and turned ordinary citizens into criminals overnight for daring to take responsibility for their own safety. But then, everything changed. June 2022, New York State Rifle and Pistol Association vs. Bruin. One court case, one decision, one sentence that tore through 70 years of gun control like dynamite through stone. Justice Clarence Thomas, writing for the majority, said it plainly: "The Second Amendment is not a second-class right." Those words landed like a bombshell in every anti-gun statehouse across the country. No more excuses. No more vague, public safety arguments. The Supreme Court set a new standard: the text, history, and tradition test. From that day forward, every single gun law in America had to align with the Constitution as written, not as reinterpreted by politicians or lobbyists. If a regulation didn't exist during the founding era of this nation, it was presumed unconstitutional. Period. End of story. That one ruling didn't just slap the wrist of states like New York and California, it shattered their entire playbook. Overnight, May issue systems became illegal. States were forced to adopt shall-issue frameworks, where qualified citizens couldn't be denied simply because some sheriff didn't like them. But here's the catch. The bureaucrats didn't surrender. They just changed tactics. Fast forward to Los Angeles County, ground zero in this new legal war. After the Supreme Court ruling, the Los Angeles County Sheriff's Department had a choice: comply with the Constitution or find creative new ways to deny it. Guess which path they took? The Department of Justice investigation exposed what can only be described as a constitutional denial factory disguised as a permit system. Out of 8,000 applications, the sheriff's office approved only 2, not 200. 2. That's an approval rate of 0.025%. Instead of saying no, they just stopped responding. Applicants were told their files were missing, their documents incomplete, or that there were no appointments available, sometimes for over 2 years. State law says applications must be processed within 90 days. Los Angeles was taking an average of 281. That's 9 months of silence, 9 months of vulnerability, 9 months of leaving good people defenseless while criminals roam free. Applicants weren't Wall Street bankers or politicians. They were single mothers, small business owners, night shift workers, the people who need protection the most. One liquor store owner who had been robbed at gunpoint 3 times waited 18 months for a response. Another woman, facing a stalker who violated her restraining order twice, was told she'd have to wait 2 years for an interview. These weren't just delays, they were death sentences wrapped in paperwork. But then, something happened no one saw coming. For the first time in American history, the Department of Justice, yes, the same DOJ that has spent decades tightening gun restrictions, switched sides. On September 30th, 2025, the DOJ filed a lawsuit against the Los Angeles County Sheriff's Department. And this time, they weren't defending the government's right to regulate guns. They were defending the people's right to own and carry them. The lawsuit named both the department and Sheriff Robert Luna personally as defendants. The message was clear: you don't get to ignore the Constitution. Not anymore. Attorney General Pam Bondi came out swinging. She didn't sugarcoat it. She said, "The Second Amendment is not a second-class right. Los Angeles County may not like that, but the Constitution doesn't care about their preferences." That's when everything changed. The DOJ accused the department of engaging in a pattern and practice of constitutional violations, a phrase that carries massive legal weight. It means this wasn't an accident. It was deliberate. A system designed to suppress a right protected by federal law. And for the first time ever, the federal government demanded a permanent injunction that would force the department to process permits on time, while placing them under federal oversight. That's right. The feds are now overseeing a local sheriff's office to ensure it actually follows the Constitution. Of course, the bureaucrats didn't take it lying down. Within hours, Los Angeles officials rushed out their excuses. The same tired lines we've heard for decades. We're understaffed. We're transitioning to a new system. Our data was taken out of context. They claimed they had approved 5,000 new permits in 2025, that the DOJ's data was outdated, and that the backlog was shrinking. But here's the problem. Their sudden burst of productivity only started after the DOJ opened its investigation. So ask yourself, were they following the law, or were they just scared of getting caught? The truth is simple. Constitutional rights aren't negotiable. You don't get to delay them because you're short on staff or too lazy to modernize your system. Rights delayed are rights denied. And that's exactly what Los Angeles did, until the federal government finally called their bluff. Let's talk about the numbers. Because data never lies. Economists studied what happens when states switch from may issue to shall issue. The results are stunning. Handgun purchases rise by 21%. Background checks go up by 35%. But here's the twist. These aren't brand new gun owners. They're the same responsible citizens who already owned firearms, finally free to carry them legally. The increase is sharpest in high-crime urban areas, exactly where people need protection most. This isn't paranoia, it's reality. When the barriers fall, law-abiding citizens arm themselves for self-defense. And what about the argument that more permits equal more crime? That's been debunked 100 times over. States with the highest number of concealed carriers consistently show lower violent crime rates. It turns out criminals think twice when the odds of their target shooting back go up. the data also revealed something else. When states move beyond permits entirely and adopt constitutional carry, gun purchases don't spike further. That means it's not about chaos or fear. It's about freedom. People don't buy guns because the government lets them. They buy them because they finally have the right to do what they should have always been able to do. Now, here's where things get really interesting. While the courts are tearing down these unconstitutional systems one by one, Congress is preparing a final strike, the National Concealed Carry Reciprocity Act. This bill, known as House Resolution 38, would make every concealed carry permit valid nationwide. If you can legally carry in Texas, that same permit would be recognized in California, New York, and every other state. Just like a driver's license, that means no more invisible borders, no more bureaucratic games. The law would preempt state restrictions and force recognition across the country. President Trump has already pledged to sign it, calling it common sense freedom. With both chambers under Republican control, the path to passage has never been clearer. But this raises an even bigger question. If the right to carry is truly constitutional, why should we need a permit at all? The truth is, the entire permit system is on borrowed time. From the Bruin decision to the DOJ lawsuit to federal legislation, the pillars holding up the old regime are crumbling fast. And the people who've spent decades denying Americans their rights are running out of places to hide. The message from the courts, the Congress, and now the DOJ couldn't be louder. The Second Amendment is not negotiable. The era of asking permission is ending. The age of accountability is beginning. This isn't just about guns, it's about freedom itself. Whether the rights written into our Constitution actually mean what they say. Because if a government can make you beg for one right, it can make you beg for all of them. And for the first time in decades, ordinary Americans, not politicians, not lobbyists, but everyday citizens, are winning. From the smallest towns in Texas to the toughest neighborhoods in Los Angeles, people are reclaiming the rights that should have never been taken from them. The Supreme Court drew the line. The DOJ just crossed it on the right side of history. And now, every anti-gun state in America is on notice. So, let me ask you this. If the government doesn't trust you with a firearm, how can you possibly trust them with your freedom? Because the truth is, rights aren't granted by the state. They're guaranteed by the Constitution. And if we don't defend them loudly, proudly, and relentlessly, they'll vanish faster than we ever thought possible. The fight isn't over. It's just beginning. The question now isn't whether gun permits will survive. It's whether bureaucrats will. So stay alert, stay informed, and stay armed. Not just with your weapon, but with your knowledge. Because as long as the people remain vigilant, liberty will never fall. Make sure you hit that subscribe button, tap the bell for updates, and drop your thoughts in the comments below. Because this story isn't over yet. Which state do you think will fight back hardest against the Supreme Court's decision? California? New York? Or will they finally surrender to the Constitution? Let's talk about it down below. And remember, freedom doesn't ask for permission.